Murder is an offence under the common law of England and Wales. It is considered the most serious form of homicide, in which one person kills another with the intention to cause either death or serious injury. Unlawfully, the element of intentionality was originally termed malice aforethought, although it required neither malice nor premeditation. Baker, Chapter 14 states that many killings done with a high degree of subjective recklessness were treated as murder from the 12th century right through until the 1974 decision in DPP v. Hume. Because murder is generally defined in law as an intent to cause serious harm or injury, combined with a death arising from that intention, there are certain circumstances where a death will be treated as murder even if the defendant did not wish to kill the actual victim. This is called transferred malice, and arises in two common cases. Murder is defined at common law rather than by statute as the unlawful killing of a reasonable person in being under the king or queen's peace with malice aforethought express or implied. The actus reus of murder was defined in common law by Coke. Murder is when a man of sound memory and of the age of discretion unlawfully killeth within any county of the realm any reasonable creature in rerum natura under the king's peace, with malice aforethought, either expressed by the party or implied by law, so as the party wounded or hurt, etc., die of the wound or hurt, etc., within a year and a day of the same. The latter clause was abolished in 1996. A further historic rule, the felony murder rule, was abolished in the Homicide Act 1957. Until abolition, the effect of this rule had been to create murder offences in two cases. When manslaughter occurs during the course of a crime, it could in certain cases be automatically reclassified by law as murder, and that any deaths resulting from acts of a criminal during the crime could cause culpability as murder on the part of all his or her fellow criminals. The effect of this rule is partly retained despite abolition. Since intent to kill is not necessary, intent to cause serious injury is sufficient for murder if death results unlawfully means without lawful justification or excuse for a killing to amount to murder by a defendant. At the time of death, the defendant's acts or omissions must be the operating and most substantial cause of death with no novus actus interveniens to break the chain of causation. Thus, the defendant cannot choose how the victim is to act, nor what personality to have. No matter whether brave or foolish, the defendant must expect the victim to. There are conflicting authorities on the above point. R.V. Jordan and R.V. Smith. In short, any contingency that is foreseeable will maintain the chain. Put the other way, only some unexpected act by a third party which places the original attack as merely a background context, or some unpredictable natural phenomenon, will break the chain. For a killing to amount to murder by a defendant, the defendant must have caused the death of a reasonable creature in rerum natura. The phrase as a whole is usually translated as a life in being, i.e., where the umbilical cord has been severed and the baby has a life independently of the mother. The Case Attorney General's reference No. 3 of 1994 is a relatively recent case involving a murder charge for death of an unborn child. The law lords considered the case of a man who stabbed his pregnant wife in an argument. The wife recovered but delivered the baby prematurely. The baby died sometime after the premature birth. The cause of death was simply that she had been born prematurely due to the effect of the attack on the mother, rather than due to any injury. In that case, Lord Mustell noted that the legal position of the unborn and other pertinent rules related to transferred malice were very strongly embedded in the structure of the law and had been considered relatively recently by the courts. The Lords concurred that a fetus, although protected by the law in a number of ways, is legally not a separate person from its mother in English law. They described this as outdated and misconceived but legally established as a principle, adding that the fetus might be or not be a person for legal purposes, but could not in modern times be described as a part of its mother. The concept of transferred malice and general malice were also not without difficulties. These are the legal principles that say when a person engages in an unlawful act, they are responsible for its consequences. including harm to others unintended to be harmed, and types of harm they did not intend. As such, in the above case where a husband stabbed his pregnant wife, causing premature birth, and the baby died due to that premature birth, in English law no murder took place. Until she had been born alive and acquired a separate existence, she could not be the victim of homicide. The requirements for murder under NLP